Good afternoon, everyone. Thank you for joining us today as we explore the realm of data protection with our webinar titled Decrypting the Digital Personal Data Protection Act 2023. In our increasingly digital world, understanding and adhering to data protection law are crucial for businesses like yours. Through this webinar, we aim to provide you with valuable insights and practical guidance on navigating the complexities of the Act. We would also take questions towards the end of the webinar. Please use the Q&A tab to post your queries. Without further ado, I would like to welcome our esteemed speakers, Aditya and Devaya, to share their insights. Over to you, Aditya and Devaya. Aditya, can you hear us? You are on mute, Aditya. Can you now, Aditya?
Yes, thank you so much, Devanshu. I'm sorry about that. Looks like we couldn't unmute. Good afternoon, everyone, and welcome to our session on the Digital Personal Data Protection Act. I have Devaya with me, and together we're going to try and use a case study methodology primarily. We will introduce you to some concepts, but primarily use the case study methodology to walk you through what it is that the Act brings and what it is that you as an organization will be required to do. A little bit about us very quickly. I'm a partner with the firm BCP Associates. We specialize in employment law, privacy, investigations. That's our forte. Personally, I have done work on privacy and certified by the Harvard Business School on privacy and technology. My colleague Devaya is also a vertical head, a junior partner, looks after investigations and advisory. His passions include teaching and has his master's from the National Law University of Jodhpur. Without any further ado, let's go into the topics. So I'm going to be discussing a few topics and then handing over to Divya. We did want to set a little bit of background and a little bit of fundamentals. So I think the most important aspect especially in a country like India is to understand what privacy and data protection are intended to do. They primarily look at bridging a gap between two things. One is looking at privacy as a right and data as a commodity. So we've had judgments in India, Justice Putswami judgment, that's the Aadhaar matter. But even before that, judgments like Kharak Singh, the Supreme Court laid down that privacy is a fundamental right. So as a right per se, it's something that everybody in this country enjoys without limitation as part of your right to life. However, it's also recognized in law that data is a commodity, which means it has economic value. There is a commercial angle to data that belongs to individuals as well. And this particular act looks to bridge these two gaps and acknowledge that there is much importance accorded to individuals' privacy while allowing for commercial interests in that data to continue, provided you fall within the regime, you do what the act requires of you, then you should be able to exploit the commercial value while ensuring that personal privacy is not breached. More importantly, the impetus for a law in India came from the GDPR. The reason we say that is while the GDPR came out in Europe and set the ground for privacy legislations globally, it also put in considerable amount of restrictions on cross-border data transfer. And one of those restrictions is that any regime or any country that you wish to transfer data to from the European Union must have in place sufficient safeguards of privacy and sufficient data safeguards. And this pushed a lot of countries to enact laws related to privacy, including India. We started, I'm sure you got the history before, we started with a bill, Justice Sri Krishna's bill on data privacy. And then thereafter, this bill completely revamped the law, and then this became law on the 13th of August. Its actual date of implementation hasn't been notified, but it's passed the Houses of Parliament. Right, so that's how it stands today. I'll hand over now to Devaya to walk you through the objectives of this act and give you a little more information about the act. Devaya, please take.
Yeah, thank you, Aditya. So just let us understand what is the objective of the DPDP Act. So one of the primary objective of the Act is to ensure that while processing personal data, there are the Act recognizes two important things. One, it protects the right of the individuals with respect to their personal data, and two, it also recognizes the need to process this personal data for a lawful purpose. So this is the primary objective of this act. One is to protect, and the other one is to recognize the need for processing of personal data. The act is divided into 9 chapters and has around 44 sections and one schedule. The 9 chapters ranging across from the title to the definitions to the rights and obligations of the data fiduciary, the rights and obligations of data principles. It also talks about the data protection board, the powers, procedures, and also all the way goes into talking into the exemptions of the act as well as the adjudication process, the grievance redressal mechanisms in place, and concludes with the penalty, and the schedule talks about the various penalties and that can be imposed in case of breach that occurs on various instances. So this is to give you a holistic view about how the act has been designed. So before going into the case studies, I think we can look into some of the concepts uh, and definitions that are very, very critical from the DPDP Act. The first and foremost we need to understand is how is data defined in the DPDP? What constitutes a data? So basically, as per the Act, data has been defined as a representation of information, facts, concepts, opinions, or instructions that can be that is suitable for communication, interpretation, and processing by human beings as well as AI. So it is given a very wide definition to bring in a lot of ambit within the definition of data. Now, this is what data it is. Now, how is it related to a personal data? The moment this data can be identified or in relation to an individual, then this data becomes personal data. So to give you an example, let's say there is a personal data of, let's say, from Devaya from Bangalore. So there may be a lot of Devayas in Bangalore. However, if it is to be related as a Devaya from BCP associates in Bangalore, immediately a person is able to relate and identify that this data belongs to so and so person. So this is the key understanding one must have in order to understand how you identify and how you relate to what constitutes as personal data. The next important definition is to understand who is the data fiduciary. So data fiduciary is that person who has the control or who determines the purpose for which the data is going that you have acquired or you are going to be used or for what purpose it has to be done. The person who determines this is considered as a data fiduciary. Now, the person who processes this particular information is called as a data processor. So we will get into what is processing. Processing can range from anywhere between to transferring, sharing, storing, or altering, or removal. Anything constitutes as processing. The processing is a very wide definition. So as and when we go on to the case studies, we will be dealing in depth to it. So data principal is the person to whom, the individual to whom the data belongs. In India, the terminology is used as data principal, whereas under the GDPR, it is called as a data subject. The reason why we have the term principal is because they did not want to call citizens or individuals as subjects. So they have given a prime importance and gone ahead and called it as data principal. So these are some of the key concepts or definitions we must understand, which is going to play a important role throughout this act, and all of them hold a very vast importance when it comes to interpretation of various provisions of this act. And go on to the concepts. Yeah. So under the concept, there are three important things that we need to understand. One is the grounds. The grounds is for the reason why you need to collect the data. What is the ground for obtaining data? So in the ground, it's based into two kinds of categories. One, it is a consent based, where you need to obtain the consent of the principal data principal for processing the data. And the other one is the legitimate use, where there is a legitimate use or requirement for usage of data. That is the second ground on which the data can be processed. So when it comes to legitimate use, we are talking about where instances where there's some sort of medical emergency, there's some sort of an obligation under the law that needs to be fulfilled, or in case of some epidemic, there needs to be reacting. You need to address such concerns. Under those circumstances, all categorized as legitimate use. And even for the purpose of employment, which we will be dealing in detail to understand how it constitutes as a legitimate use in the to our presentation. So once you have understood the grounds, that is either through consent or for a legitimate purpose, the next step that comes into picture is notice. Notice is where the data fiduciary, that is, has to issue a notice to the data principal by saying, see, I am issuing this notice to take your consent for usage, for what purpose, what data I'm going to collect, for what purpose I'm going to use it. And it also, the notice should contain and say that you have a right to withdraw the consent, as well as in case of any breach, you can approach the data protection board and file a complaint. So these are some of the elements that needs to be there in the notice while you're giving this notice. Another important thing you need to understand it when it comes to providing consent is that in the notice, the easier way, how easy it is to provide the consent, it should be the same mechanism should be adopted even while withdrawing. Normally, we see while giving consent, it is very easy, but when it comes to withdrawal, the procedure is very complicated. Such a procedure cannot be there. Once the notice is given, there is a requirement to provide consent. The consent is done by the data principal for providing the principal providing personal data, and it should be in a free, specific, informed, unambiguous, unconditional manner. More importantly, it should be an affirmative action saying, yes, I give my consent for usage of my personal data for the following purpose. And the purpose should be very specific and should not contain any ambiguity. And once the consent has been provided, it should also contain for what specific purpose is going to be used, how long it is going to be used, and to what extent the consent is going to remain in force. Also, the language in while providing consent should be very clean, in a clean, plain, and a clear manner. It should not. It should also be in the language which the data principal is able to understand and provide her consent. So this is what, when it comes to the ambit of providing consent, becomes very clear. Now, once you have your consent, we need to understand the applicability. This is where the provisions of this particular act applies. So Data Privacy Act or Digital DPDP Act basically applies to all personal data within the territory of India, where the personal data is in the form of a digitized form, where it's already in a digital form. And second, it is applicable in the event where you take a non-digital form but subsequently convert it into a digitized form. In these two instances within the territory of India, the act is applicable. And also it is also applicable where, let's say, the personal data is being processed outside the territory of India, but with reference to the data of principal data located in India. So let's say, to give you an example, the best example here is earlier what Visa used to do was, Visa or MasterCard, they used to process the data of principal data of Indians outside India, whereas they were conducting businesses in India. So under those circumstances, as on today, I mean, now that they are in India, but otherwise, under the DPDP Act, even though you're processing the data outside the country, you are still governed by the provisions of DPDP, because for the simple reason you are processing information pertaining to the data principles located within the territory of India. The Act does not apply in two cases where you have where the data principal herself has provided the data on a public platform, and all, or in case where the data is used for any of a personal or domestic purposes. Under these two circumstances, or also in the case of where it is there's an obligation under the law that you need to provide data. Under these three circumstances, the act does not apply. So these are some of the overall view for to understand about regarding the applicability. There are certain exemptions that is being provided. The exemptions are with reference to certain chapters and not in entirety. The act will apply in entirety, but there are certain exemptions that comes in where you don't have to take notice, don't have to provide consent in case where you're enforcing any legal right, or where the personal data is required by any court of law or tribunal, or where it is required in the interest of protecting or detecting of any investigation or a crime or offense, where there is some sort of scheme or compromise that is involved in case of a merger and acquisition of a company, and also for processing any data to do with where any financial information needs to be ascertained with reference to an individual who has defaulted in a loan. More importantly, there's one important exemption, that is where the personal data principles not within the territory of India is processed pursuant to a contract entered by any person outside the territory of India with a person based in India. So to give you an example, I'll tell you why this becomes very critical. This exemption is in case of movement of data or cross-border data from one jurisdiction to another jurisdiction. So in this particular clause, what basically it says is, so to example, let's say the data principle is in Germany, there is a headquarters company, and whereas in India, you're doing a back-end work with reference to the data of the citizens of Germany. Under those circumstances, all that is required is that there needs to be a contract between the entity located in Germany and the entity that is located in India, which we normally refer to as a standard contractual clause. So if there is this agreement, and through this agreement, the interests of the data principles, that is the citizens of Germany, are protected as long as they are in compliance with the GDPR laws. The contract is brought into force, and they are also exempted from the DPDP Act. However, there is more into it. Probably Aditya will deal it in a little later when it talks about the Schrems Act and the Schrems 2 case law by the European Court of Justice, and how this has impacted the cross-border requirements. So with this is to give you a holistic view of the exemptions that are there under this act that comes into picture.
Thanks, Divya. So I think, a lot of fundamental concepts that we've dealt with here, we will deal obviously in more detail. And we've, like I said, adopted that case study methodology to look at a few scenarios within, your own operations as a company, and to see where and how you would apply the DPDP. So let's get into that, and first let's look at the data of a candidate. So for our discussions today, our subject is a person by the name of Kishore. We've chosen that name at random, and he's typically, an employee who's looking for a job right now, and he applies to your organization. He's a data scientist. You look to hire him. So there's a typical scenario that could arise in any of your companies, and you need to conduct a BGV for him, right? His background verification needs to happen. So how does the DPDP impact such a situation? Now, typically the way BGV happens is that, or even before BGV, the way recruitment happens is that you have sourced his resume from a recruiter, a provider, service provider who's given you this resume, and this resume contains what we like to call personal data, otherwise known as personally identifiable information in other statutes, like the GDPR, or in the US, states like California use that nomenclature to use to call out information that helps you identify an individual, right? So all this is there in the resume, and now you have this data with you. Obviously, it's in digitized form, which means the act applies. Like Devya said, Section 3 would bring this within the purview of DPDP. Now, what happens in such scenarios, right? First question that you need to ask yourselves is, now, since the way DPDP operates is that in order to process data, you need to either have consent or it needs to be a legitimate purpose. These are the only two grounds under which you can process data. Now, in this particular instance, would you need to get consent, or do you have a legitimate purpose? So if you look at section 7, it alludes to a legitimate purpose, one of the legitimate purposes. It has A to I, and I talks about employment. It uses the terminology for the purposes of employment. So if you need to process data for the purposes of employment, it's a legitimate purpose and you can do away with consent. So the argument here would be that if I have to employ the person, I have to conduct a background verification, and therefore this data processing is towards employment, and I may be able to bring it within that broader head of for the purpose of employment and do away with the requirement of consent. However, it's very, very narrow. You could only do it in relation to employment, and anything apart from employment or outside of employment, if that were to happen through your BGP process, then that could amount to a breach because you haven't obtained consent for that purpose, right? Now, we also have an interesting scenario of the resume coming from publicly available portals like Monster or Naukri or any of these other portals that have resumes. And presuming this individual Kishore has uploaded his resumes on that portal, do you still need to look for consent? So one of the illustrations that Devya was referring to under section 3 says that if it is publicly available information, and the illustration refers to someone who puts up their information on a blog and says that if that information is publicly available, then the question of consent doesn't arise anymore. So here, again, an argument could possibly be made that portals like Naukri or Monster or wherever this individual has uploaded their resume is a public domain. And therefore, since it's available there, I may not need consent. But we'll have to see how these arguments play on, or rather how they perform when we actually have a scenario before an authority, the authority in this case being the board. Also, an important question becomes, does this candidate now have rights in relation to you? You being the prospective employer, right? So the answer here is yes, he does have rights. Now, whether there's consent, whether it's legitimate purpose, you may or may not need to get consent. It doesn't mean that the act does not apply. So the rest of the provisions of the act, including the rights of this data principal, are available under the act, despite the fact that he's not given you consent or you've not sought consent. These rights include the right to say, delete all my information, the right to say, tell me where my information is. I want to know who you've given it to and who has processed it and what you've passed on. So all of these rights are available to a candidate in your BGP process, and he can come back and say he wants you to basically expunge the data. And if there's a breach, what's your liability? So they will allude to what your liability is if there is a breach.
Yeah, if there's a breach in the liability, so one of the key things is where the amount of fine varies anywhere up to 250 crores. That's the breach. And more importantly, if you have not given sufficient protection or in maintaining the personal data.
Yeah, I think one of the biggest issues we see here is that the prerogative is in the hands of a board. And we've seen this play out before other boards. If you look at the Competition Commission of India, for example, we've seen this tendency to have huge awards passed against corporates. So we don't think the board is going to hold back, and any instance where it sees that there aren't mechanisms in place, it's resulted in unauthorized processing of this information, they are going to levy fines, and there's only huge upper limit there, beginning at a lower limit also, which is pretty high. So the risk of breach is very high in such cases. Right. So now Kishore's BGV is done, and you've decided to now take him. He's joined your company. Obviously, when someone joins your company, you collect a whole bunch of data again, and this data includes information about him personally. It includes information about his family members, because you're going to process things like insurance, nominations. You need to have an emergency contact. You have policies in place today that say all of this data needs to be collected, and you've collected all of this data. Kishore has willingly given all of it now. Now the question is, typically we would nominate a spouse or a parent or a child. We'd also give you their contact information, right? Which now makes the data as defined under this act, personal data, and it's in digital form. Because using that data, you're now able to identify the individual. And what happens in such cases where you've collected data from one individual about another individual, and do you need consent to process that data from the other individual? So we don't look at it from this lens today, but under this act, it might become important for you to obtain consent from the spouse or the parent or whoever else this person uses as a contact, being an emergency contact, because that person's data is also going to be processed by you as a company or as an employer, as a data fiduciary and a data processor. You're going to process this information. Now, that begs the question, what is process? Did give you the definition of process, but to put it very simply, if you're collecting information in digital form, it is processing, irrespective of what you do with it later. So in this case, you are processing the data, and consent from people who are not the employee may be required, because for the employee, you have this whole Section 7 giving you the benefit of saying legitimate purpose of employment. But for someone who is not related, the purpose of employment argument may be a little hard to make. There are other arguments that you can make within the same section, which says you're collecting data to give him certain benefits, but the interpretation of that clause, whether it is limited to data from him about him or her, or does it extend to other data which they provide about other individuals, that argument, we'll have to see again how that plays out. In our opinion, it might be a stretch to imagine that any data received from the employee could be brought within that bracket of for the purposes of employment. Now, also we have this practice of companies deploying these individuals abroad, right? This could be for training, this could be on projects. Now, let's presume that you took Kishore, you sent him abroad, you sent him to Germany for training. What typically happens in such cases is one of two approaches are followed. Either the company says, you'll continue to remain on my payrolls, I'll pay you in India, you'll get a stipend in Germany, in which case his data is being processed in India while he is not in India. Now, one of the things Deva was talking about was the applicability where you're processing data of someone who is not in the country, right? So the Act does not talk about citizenship. The Act does not talk about nationality. It's only concerned with the geographical location of a person. So it says if the person is located within India, the Act applies to you. If that's the person whose data you're processing applies, you're processing that data in India, it applies to you. If the individual is located outside India and you're processing that data, then this Act may not apply to you, right? So with that being the case, this will bring about a few predicaments when this person is abroad. You might be processing his data in India, this person might be abroad. Now, you need to have a contract in place for you to get an exemption of the Act. Under 17, it exempts such data processing, provided you have a contract to process such data. So then you might have to enter into a contract with the parent or wherever you sent him for training to say, hey, I'm going to process his data while he's not in the country, and then you can get an exemption from the Act. If not, then the Act would apply because the data processing is happening in India. In the second scenario, in such cases, you might outsource the entire payroll to the foreign entity and say, you take care of it. We're just going to keep him on our rolls here. Even in such case, the fact that you have him on your rolls means that his data is being processed. The same requirements for you to have a contract with that entity in order to come within the exemptions under Section 17 may be invoked. Do you have anything to add, Divya, on that point?
No, this is good, sir. So just to add on to here, I want to bring in talk about the Schrems to judgment by the European Court of Justice, where you have a contract that's a standard contractual clause, but this has again been impacted by the judgment, wherein it says, in addition to this contract, you also need to make sure this is applicable only to those countries that are based out of EU. You need to make sure that there is a transfer assessment impact. So basically, when the data is being processed in India, you need to make sure that they have been given sufficient protection in lines with the GDPR, as well as they are also able to enforce their right within the limits of India as well. And the India also has provide certain protection measures in order to see that the personal data of the individuals outside India are also protected.
Thanks, Deva. Yes, you bring up a good point, which stems to, I think, the regime of GDPR has become a lot more stringent when it comes to cross-border transfer, and the impact assessment along with your SCCs has to be done to ensure that data subjects or data principal in this case rights are protected globally, right? Does Kishore have any other rights in such a scenario? So this STREMS 2 covers it. He might, if he's in the EU, he might have rights in addition to just DPDP. Whatever rights are available under GDPR may also be available to him depending on where the data originates. As a employer in such a situation, what are your duties, right? So irrespective of whether again there is consent or no consent, whether you're going with um, a exception under section 7 to say that it's a legitimate purpose, you don't need consent, there are still duties that attach to you irrespective, and these duties primarily relate to the protection of the data that you hold. So you are required to take all reasonable steps, be it through infrastructure, be it through policy or procedure, to ensure that there are no data breaches or unnecessary, unauthorized processing of data. So both of these need to be ensured, and as an employer, you have these duties. In addition, you have the duty of ensuring that upon a request for grievance redressal, a grievance be redressed, upon a request for change in data, be it either amendment of the data, correction of the data, or erasure of the data, you are able to comply. Now, this is easier said than done. We might think it's quite simple to comply with these requests, but the problem is that every point where this data has gone needs to be able to be reached for all of these activities. When I say that, I mean you've sent this data now to Germany in this particular case. You need to ensure that the correction happens in Germany as well. You need to ensure that if erasure is requested, you erase data in Germany as well in relation to this individual, which might not be as simple as it seems. Now, another very important question, we have, all of these exemptions under section 7 which says for the purpose of employment. Does that apply to a consultant, a trainee, or an intern? I'm sure all of you hire, consultants. And when I say consultants, I'm not talking about agencies. I'm talking about individuals who, instead of giving an appointment letter, you give a consultant letter. Do they constitute employees? Similarly, you have trainees, interns who you do not give appointment letters to. You bring them on boards. And again, you collect all of the data that we're talking about in relation to Kishore, whatever you collected, you'd collect in respect of these individuals as well. Now, unfortunately, you don't get the benefit of section 7 here. This is not employment. The argument that this is the purpose of employment cannot be made because it would contradict your own stance later that this is not an employee for purpose of other statutes like in the Provident Fund Act or the Income Tax Act. So you'd have to maintain, one stance on both fronts. You'd have to say this is not employment, which means for such individuals, you would have to obtain consent. So you'd have to follow the procedure of notice like they were said under section 5 and obtain consent under section 6, which is not simple again because consent, we will deal with it, but has to be obtained in a certain manner and to cover all activities that you are possibly envisioning doing with that data. Right. So you have this employee now, he's working for you. He also has to deal with customer data because that's his job. He's a data scientist. We've picked one jurisdiction, the US, but we can also look at this person, working with data sets, let's say from Germany, let's say from the US together, right? And let's say the project that he's working on is this project of e-discovery. Your parent company is located both in Germany and the US, and large amount of data, which is, emails, medical records, court records, all of these things, this data scientist reviews. He has a team that segregates, but effectively that is his purpose. That's his job, right? So now with that in mind, after DPDP, can you actually continue to perform this work in India? I know we have a lot of GCCs on this meeting. So can they continue to perform, this kind of function in India in relation to data of their parents, right? So that's a critical question. And the answer to this question, again, Devaya has, during his introduction, pointed towards it and said that it is feasible, it is possible. So if you look at 17(1)(d) of the DPDP, it actually allows you to perform such kind of cross-border data processing in India without the need for consent, without the need to provide for things like erasure, provided you do it under a contract that you enter into And that contract, although the DPDP doesn't say it, but we know the rules are going to come out with it and say that this contract is going to have clauses which ensures the protection of that data while it is in India. And those clauses will 100% ensure the way they ensued from GDPR as well. So in a nutshell, while you can perform this work, it is going to have to be through a contract. Now, the question is, what is this contract? Can I have a generic contract that says you provide me services? Today, a lot of you work on transfer pricing. Transfer pricing may not have details. It may simply be a seat-based or a headcount-based contract, which simply says, this is what I do, this is my cost, and I take an overhead. Is that sufficient? The answer is going to be no. You're going to have clauses that specifically talk about data transfer. You're also going to have clauses which talk about data processing. And this kind of a contract may be required to be produced before the board if there is ever a challenge on whether you can actually process that data in India or not. Now, let's presume this data it's a mixed set of data, because I think the biggest issue we're going to have in the future is these sets of data that are mixed, that have data which belongs to individuals who are of different nationalities. It also belongs to or rather has data from individuals who are located in different geographies, right? So let's presume here there are claims made against the company. Here, this is a retail outlet that your parent is, and there are claims made by Indian nationals who at the time when the issue happened were in the US, but now are located in India. What happens in such a case? Does this change things around, right? So if in the scenario that these are Indian nationals who are based in the US, you continue to get protection under 17(1)(d). But if that mixed data set has data belonging to individuals who are in India, located in India, that exemption is gone. So you cannot claim to not have to take consent anymore. You now have to follow the path of consent or bring up the cause of a legitimate purpose under 7. So I may be able to make the argument that this is a court case. I'm trying to enforce rights, and therefore I have an exemption under both 17 and under 7 from consent. It's possible to make that argument, but this is one scenario. I'm sure you can envision multiple scenarios where there is no such court case or right to be enforced. In such cases, you will not be able to make that argument, right? What if the data belongs to the customers of your parent in the US? Now, is it all right to process it here? So here the answer is quite simple. 17(1)(d) allows you to do, provided you have that contract. But in addition, you may also need to safeguard yourselves locally. So I think you can add here, if you want, from a GDPR angle, let's presume this was from my parent in Germany, right? What would I have to do?
Yeah, as a parent in Germany, you would expect the Indian entity to see that when personal data is protected, there are strict mechanisms in place to see that the confidentiality is maintained. That is one thing. In addition to that, they also need to make systems in place where they can enforce their right when it comes to their any breach in the personal data. These are some of the two important things that needs to be looked into.
Thanks, Devya. So this was our, obviously our scenario 3, where the employee is now working with different data sets, right? Now, moving forward, let's presume now that this employee has had a good run of about 6 months. Before that, we look at vendor data and what happens in cases of vendor data, right? So your company cannot work with only its own employees. You're also going to have contract staff. So you find that the workload is too much. You need staff augmentation. So you go to this company called IT Kings, and they agree to provide you support. And let's say you need a headcount of 10, 15 people. Now, these people who need to join your company to provide you support as contract labor, they're not going to be on your rolls. They're not your employees. So does that exemption for the purpose of employment under Section 7 apply to you? That would be one question. But more importantly, you need to carry out BGV before they even come or are given access to your premises. They're not your employees, right? So they need to provide personal data in order to ensure that BGV is completed. Also, to provide benefits under labor laws, you need to get personal data from these people. Now, question here is, who needs to obtain consent? I think I'd take it one step further and say, do you need to obtain consent at all? That would be question number one, right? So the answer here is that you definitely do, that is, as an employer, you would not be the data fiduciary in relation to these employees because they're not your employees. The contractor, which is IT Kings Limited, would become the data fiduciary, and you would possibly become only a data processor because you're receiving this data. So the onus of consent would now fall on IT Kings. They would have to showcase that they have an exemption under 7I and they don't need to obtain consent. And because they don't need to obtain consent, when they need to process the data for you or you need to process the data, you don't need consent either. So that could be the possible argument that they could make. But we have to ensure that it is for the purpose of employment. So the amount of vigilance you're going to have on that engagement between IT Kings and these individuals, that is going to increase considerably. Right? Now, I answered this question already. Who will become the data fiduciary? Now, Divya, you might want to go into what safeguards the company will have to take in relation to such data.
Yeah. One of the things when it comes to safeguarding is that the company will have to make sure that the data has been transferred to the BGB vendors, and whether the consent has been taken into consideration in that. That's the first thing. The second thing also that needs to be taken into consideration is what kind of data that is being shared with the BGB vendors are some of the critical ones, and to what extent to who the BGB vendors are going to share this with any other third party are some of the things that the company will have to keep in mind. So to what extent the data is being moved or to how far the data is being shared are some of the key factors the company will have to keep in mind, and also see that it still holds a control on that personal data, because there may be a situation where the employer may come on a later date and tell that I want that data, whatever whom you have shared with the BGB and who subsequent to whom the BGB vendors have shared, all to be erased, or I need to be told who are these uh, individuals or who are these concerns that have access to my data. So there needs to be a complete control when it comes to how far fetching the data has been shared.
Absolutely. And in addition, so my next question is, can the company further provide this data to others to process, right? So interestingly, here you may have different scenarios. One of the most common ones we see is that these contract workers then get absorbed by the principal employer. They say, now you're going to be my employee. I'm going to issue you an offer letter and take you on board. So what happens to these data sets that are now lying with the contractor? Can this employer now provide this data either when this person is a contract worker or an employee to a third party or someone else to process? Now, ideally, there has to be a chain of command when it comes to this data and getting it processed. So they would need IT Kings to sign off on any further processing that they would need. So when I say chain of command, what I'm trying to indicate is that the ultimate control is with the data fiduciary, which is IT Kings, and IT Kings is the only one who can actually give it to other processors. So when it comes down to your company is basically have to go back to IT Kings to say, hey, I need to be able to process this data in a certain way. Can I do it, or have them do it themselves? Now, these are real-time scenarios that may occur in any company, right? You have contract staff who work in your organization and you want to provide them benefits that are on par with your own employees. And these benefits may include things like as simple as an outing, a team outing. And for the purposes of the team outing, let's say you have an event organizer who now needs the names and phone numbers of everybody because they need to be picked up from different locations. You need to coordinate and take them to place X. You are now giving data to a third party to process. Do you have the ability to do it under the Act? So technically the answer is no, because you're not the data fiduciary for this data. You're only the data processor. So without the data fiduciary's consent, or rather without the data fiduciary actually allowing for such transfer, you cannot do it. So that becomes, a proposition that you're going to have to weigh in, as this act plays out. You also have visitor data, right, as a company. So you've dealt with employee data, you've dealt with candidate data, you've dealt with company data. But one of the other large sets of data that you're going to possess is visitor data. And today, most of our tech parks are, very tech savvy, and they have a third-party service provider who has an app You don't have to do much. You take your picture, scan your ID, and you get a visitor pass on your phone, and you can enter the premises, right? So this is a typical situation today. And what happens to such visitor data? How is this treated, right? I think the first and foremost question is, do you need to obtain consent for visitor data? The answer here, I think, is unequivocally yes. You will need to obtain consent. Primarily, it looks like the mechanism you'll use is that the notice will go out through the app, the consent will be obtained through the app, and then you'll issue your visitor pass, etc. But consent is a definite yes here, because you don't enjoy any exemptions under 7. You don't have the argument of saying that this is a legitimate purpose, because the visitor could be coming to do anything. This could be any kind of visitor, right? Now, who is the data fiduciary processor? Is the app the data fiduciary? Because they're obtaining the data. Are you the data fiduciary? So the answer here is that you are the data fiduciary, because you are engaging the app. The app is only a service provider. You will remain the data fiduciary, and the app will become the data processor. And in case of breach of data, you're going to be liable as a fiduciary. So you have to ensure that the app or the company that you work with has sufficient safeguards in place to ensure that there is no breach. There were anything to add here?
Now, just to add, in case of a breach, both of them are jointly liable, is something that needs to be kept in mind.
Great. Right. Now, how long can you retain visitor data? Now, this is a tricky question, right? Because if you look at the DPDP Act, it allows you to retain data only as long as you actually need to process it, or if there is a law or a stipulation to the contrary, then you can retain it for as long as the law requires you to. Now, in case of visitor data, there is no law. The law doesn't say you need to. And this visitor data, mind you, could be a lot of things, including things like CCTV footage. If a person is readily identifiable by his face, CCTV footage could constitute personal data, right? So how long can you retain this data becomes critical. From a safety standpoint, you might want to retain it for a long period of time. If I take the example of the recent blast we had in a cafe in Bangalore, right, a bomb blast. So the retention of the CCTV footage led to obviously the police got it immediately, but presuming you had other information and the incident wasn't as grave, let's say it was theft of something which came to light 25 days later or 30 days later, is it reasonable for you as a company to have retained data for that long, is the question. So today we don't have an answer for this. The rules may give us more clarity, but as far as the act goes, it is purpose driven. So as long as you have a reason to retain that data because you need to process it, you can retain it. Beyond that, it becomes unreasonable and you need to destroy that data. So this question, we'll see if the rules can help us better answer. And I think one of the last scenarios that we're coming to is what happens if the employee exits, right? So Kishore has worked with your company now for about 6 months. In 6 months, you've gathered a ton of data about this individual. You've transferred this data also to multiple entities. This could be insurance companies, BGV companies, teams within your organization. So there's an HR team, there's a benefits team, there's a comp team. All of these people now have that data. It's also been sent to, let's say he applied for a car loan through the organization. He has a car lease program. You've conducted training sessions where you've said, these are the attendees, here are their phone numbers, here are their email IDs. Clients have the contact information and the name of the person, which now constitutes personal data. Supervisors in India, abroad, all of these people now have data belonging to this individual, right? So first and foremost, it's an exit employee. How long can this personal data be retained? Now, again, it gets tricky here. There are laws, especially labor laws, that require you to retain some of this data for a reasonable period of time, which could be up to 5 years. But that's limited to certain kind of information. You might need the person's name. You might need things like his PF account number, his salary details. Is that personally identifiable data? May not be to a person in the public realm, but definitely for an authority like the PF authority, they could use the PF number and the name to identify an individual. However, you're safe on that count because the law asks you to retain it. Therefore, you're covered, you can retain it. But other pieces of data and information like email ID, phone numbers, pictures, coupled with some of this data, are things that you don't need from a legal lens to retain anymore. The problem that you'll see here is that this data has gone to many different people. It has, you may not know how far this data has gone. Now, if the employee requests, right, which is my next question, the employee comes and says, I want you to delete all personal data that you have that belongs to me. Now, this is a very real scenario. I'm sure employees are going to get educated about their rights as well. And they're going to come back and say, I don't want you to retain my personal data. You have no reason to. So please expunge everything that you have. You're going to have to be able to trace every no, first, you're going to have to say, be able to trace the source of your data. You're also going to have to be able to trace every person and every institution to which this data was sent. This request for erasure is going to have to go to all of those people, and you're going to have to ensure that it is erased. So that would be your role, to look at the entire data flow, see where it is reached, and see if it has been erased based on your request. Is there anything else you can ask for? Absolutely. He can ask for a lot of other things in relation to the data, primarily how much of this data you sent, who you sent it to, what is the list of people who have received this data, why have they used it, what have they processed it for. These are the questions that he can ask. But an important one is what happens when a BGV request comes to you. Let's say it comes 2.5 or 3 years later saying, hey, this employee worked with you in your company, and this is his phone number, this is his name, this was his designation, last known address. Can you validate this information? So when you get a BGV request like this, what are you going to do if you don't have this data because you didn't need to retain it, right? So this is a question companies are going to have to ask themselves and see how it plays out. Most often they're going to say we don't have the information, and what's that going to result in for the employee is something that we're going to have to see. Right, with that, I'm going to hand over back to Devaya and he'll walk you through compliance requirements.
Thank you, Aditya. So, in order to be compliant with the Act, you need to bring out certain changes. So, changes I've divided it into three parts. I'm going to talk about from a policy standpoint, then on from a procedural standpoint, and from an infrastructural standpoint. From a policy standpoint, the first and foremost thing you'll have to do is you'll have to revise and relook into your existing agreements and communicate the obligations regarding data processing. So the manner in which the data has to be processed will have to be clearly documented in the form of the agreement, and it has to be communicated to the concerned people who are going to process the data. Secondly, you'll also have to, from a policy standpoint, create and update or update your existing policies in order to see that they are in compliance with the provisions of the DPDP Act. You also will have to develop standard privacy notices, consent forms for functioning of the company. You'll have to have a set format when you have the notices. Obviously, there won't be certain changes with reference to the purpose and also with respect to the obtaining of the consent, but you need to have these documents in place, as these are some of the mandatory requirements. Further, you also will have to categorize the data, and also you'll also have to see that how much of data you need to store and for how long you will have to store them as per the statutory requirements that are there. More importantly, you'll also have to create an awareness and also have to train all your stakeholders, including your employees, to know what are their rights and obligations under the Act. This is all that is required from a policy standpoint. Let us now see what are the procedural changes you need to carry out. From a procedural change, you will first and foremost you'll have to identify, you'll also have to see your who and chart out your data processes and the kinds of data that is going to be shared with each one of them. The reason why this is required is that in order to see that how far your data is being processed, the personal data is being processed, and how much of control you can have over it. You also will have to list down the third parties handling the personal data, who are the third parties and whether they have all the documents and agreements in place when they are processing the personal data. You'll have to lay down clear and strict data protection mechanism, as this is a mandate. In the fine for breach of this is 250 crores when it comes for any breach if you do not have a data protection mechanism in place. So you'll have to be very clear, and you'll also have to invest a lot of time into see that this mechanism is brought in place and the same is in compliance with the provisions of the DPDP Act. You also have to create procedures in managing the requests from personal data, from data principal, as well as addressing their rights. you have to bring in a process with reference to issuing of notice, obtaining of consent, withdrawal of consent, as well as making alterations to the personal data. So these are some of the mechanisms and procedures and processes you will have to put in place. Also, you'll have to see that you'll have to create a data breach management process, and also the protocol that needs to be followed in case of a breach. So immediately, if you're able to identify that there's a breach, what are the steps that needs to be followed in order to mitigate that breach should also be put in place. In addition to that, you need to have a grievance redressal mechanism in place, because that's a mandate under the law, and also a mechanism for erasure of data. So all these are some of the procedural changes that you will have to bring about in order to be in compliance with the law when it comes to procedures. Infrastructural changes, what are the mechanisms that you need to bring in place? You need to first and foremost identify the kinds of personal data that has been collected, processed, and transferred, because this under these circumstances, you are in a position to determine where the data is, who's processing it, and how far the data has been transferred. You also have to implement a consent management and a consent withdrawal mechanism. Like I told you in the very beginning, the manner in which you take the consent, the same manner the data principal should also be able to withdraw that consent. The infrastructure should be such that it is easily understandable and specific consent procedures are put in place. You can't have too many procedures or mechanisms in place in order to provide the consent. At the same time, there should not be too many procedures when it also comes to withdrawal. It has to be very simple. It has to be very straightforward. You also have to bring in tools to see and streamline the appropriate access to the appropriate resources. By this, what I mean is that not everybody needs to be having access to the data of personal data of the data principal. There needs to be access. It should be access controlled. Only those people who are authorized should be provided with access to the personal data. You also need to implement an information security practices and mechanisms should also be brought in to see that the data is protected. And at the same time, you also need to provide in measure tools to erase the data. So these are some of the infrastructural changes that you need to bring. As long as you have brought in the policy, the procedural, and the infrastructural compliances, you stand to be in compliance with the act. I think we can move to the best practices.
Yeah, I think we'll look at a couple of things that we need to ensure in terms of best practices. I think the first and the biggest issue is that of consent. We'll take a couple of minutes here. So if you look at the act itself, it defines consent as consent which is given first and foremost freely. I think that's the most important. Now, the word freely is not defined, but if you look at contract law and other statutes that we have, free would imply without duress, without compulsion, without a situation where the person has no choice or is in a situation where one person has a controlling power over the other, that consent may not be deemed to be free. To give you an example, under GDPR, for example, if I'm not provided a service, if I don't give consent, that consent is not deemed to be free anymore. Unfortunately or fortunately, the DPDP takes a little lower stance and says that the data principal will take, or rather will bear the cost of not giving consent. So it doesn't put that burden on the data fiduciary. So effectively, if a data principal says, I will not give consent and therefore does not get a service, it does not hold the data fiduciary liable in any way. But anyway, this whole concept of free consent is going to be probably the toughest threshold for any company to meet. In addition, it says that the consent must be specific. So for every purpose that you wish to process the data, you're going to have to put that down in the consent, in the notice, and then get consent on that. It has to be informed, which means they need to understand it in their language. The Act says it should be either in English or one of the 22 languages which are in the Constitution. The person can ask for it to be in any of those languages. You should be able to provide it. It has to be, and one word which is not there either in the California Consumer Protection Act, the GDPR, or the Singapore Act, or a few other legislations that we've reviewed, is the word unconditional. So the Indian statute uses this word unconditional, and it's going to be a little tricky because it means that when I give consent to everything. I don't have a choice of saying I have a limited scope of giving you consent. So this is going to be a little difficult, unambiguous, specific purpose, and also last but not least, clear affirmative action, which means any form of deemed consent, pre-clicked consent, failure to disagree kind of consent will not be valid under this law. It's going to have to be something with an affirmative action. Some of the best practices for cross-border transfer are going to be to ensure that you review central government restrictions. They have the ability to say that data should not go to certain countries, which means you will not be able to send them. You'll also have to look at restrictions under other laws. If they're more stringent than the DPDP, those would prevail. For example, today the RBI has restrictions on transfer of payment-related information that to go out of India. It's an absolute blanket restriction, and that restriction will still have to be followed. You'll also have to look at the law of the country where the data is going to see if they have restrictions. Ultimately, from a storage and erasure standpoint, you need to have safe storage, secure storage. You need to have the ability to report a breach, which means you also need to have primarily the ability to identify a breach. You have to have the infrastructure to be able to delete upon request, and data has to be able to be tracked at all times, which means you need to know where data is going at all times. So these are some of the best practices that you're going to have to ensure. I think with that, our presentation, it's a wrap. We did want to spare some time for Q&A, so I think we're right on point. There are a few questions in the chat box. Devanshu, would you want us to take them up?
Yep. Yeah, that's sure.
Okay.
So I'll read out the questions to you. Maybe you and Devak can then answer. So this is a question posted by Shreya. The question is, in the scenario of CV posted on publicly available platforms, the consent is still for the employer to contact the employee for taking the candidature further. Is it still does not employ consent for BGV? Would you agree?
Yeah, so interestingly, when I post information on a public platform, under the Act, consent itself is not required. So it takes it away from the purview of the requisition of consent. It means I can process that data without your consent, and it can be for whatever purpose that I choose to. So technically, no, it's not that that information is only to contact you. That information is available in public domain, which means I can take it and process it the way I want to process it. That's what the law seems to imply.
The next is from Nitesh. He is asking, what if the employee directly provides nominee details on the PF or insurance portal?
Yeah, I think more and more that's going to happen. Employers are going to want to say, look, I don't need this data. So don't give it to me. You take it straight to the portal, and any data provided to a government authority or for the purposes of giving you a legal right or benefit are outside the purview of this act, which is why companies, I think, more and more will want to, do that.
Next one is asked by Darshan. When HRMS is synced with GMC policy, especially when we have Insurtech team who uses the employee data from employer to TPA, and the insurance company, what would be the stand here from the Data Protection Act 2023?
Yeah, unfortunately, too many abbreviations here for me to understand. Maybe Darshan, you can unmute and ask me the question. So while I get HRMS, I understand Insurtech. I'm not sure what TPA and GMC mean.
Which we'll move on to the next one. Maybe I'll drop in my email ID at the end of this. Maybe they can write to me directly and ask the queries, and then I'll pass it on to you guys. The next is from Kalyan. When an employee leaves his organization, how long the employer can hold his personal data information, and how the employee will be notified that his data being destroyed and no longer with the organization?
Yeah, so there is no, like I said, there is no prescribed time frame, but statutes other than the DPDP, which is statutes like the Provident Fund Act, minimum wages, payment of wages. We have labor statutes that allow you to hold this data or require you to hold it for a reasonable period of time. That reasonable period of time under some statutes is deemed to be 3 years, under others 5 years. So that is the maximum tenure that you could, hold it for. Unfortunately, under the DPDP, there is no need for me to inform you that it has been erased unless you make a request for erasure. If you make a request to me for erasure, then I have to inform you that it's been erased. If you don't, then I don't have that burden of informing you.
The next is asked by Rupali. When banks collect data for KYC or while opening account or availing bank facilities, is bank a data fiduciary?
Absolutely. So bank is a data fiduciary in such cases. they will have to collect that for a restricted purpose and use it for a restricted purpose. Although things like banks are to provide me with a facility or benefit, so they will fall under the exemption section 7. The way you can correct me if I'm wrong, but the purpose for which they collect it, it has to be limited to that purpose alone.
Correct. Your understanding is right.
Yep. Then again, the next is again by Rupali. She's asking, banks enter into third-party agreements with bank insurance, vendor agreements, etc. If data is leaked by such third party, is bank liable? And if yes, how to safeguard the bank from liability and responsibility?
Absolutely, like they were clarified, both are liable. So the data fiduciary and processor are going to be liable. The only way to safeguard is to ensure, again, that data only goes or is transferred only on an absolute requirement basis. And secondly, the person who's receiving the data has the same amount of controls in place as you do, the same kind of controls in place as you do to ensure that there are no data breaches.
The next question comes in from Dinesh. Which is the provision that deals with the right of individual to enforce the right to delete or right to be forgotten? Is that right be enforced against government fiduciary?
Yeah, so this act does not apply to data held by a government. So in that sense, the right to be forgotten totally is not available. However, the provision is section 12 allows the data principal to make a request for erasure of data, but it does not apply to the government.
The next question is from Nishit. Is it a requirement that DPO needs to be local? Secondly, if data transfers to US, can there be cross-border transfer for employees' data?
So first of all, I think the requirement for a DPO is not there for all organizations. It's only for organizations which are deemed to be substantial data fiduciaries. And the definition of substantial data fiduciary goes back to the volume of data that they have, the kind of data that they have, and the kind of processing they do. So based on that, the central government has the power to declare them a substantial data fiduciary. They are required to appoint a DPO. And if that requirement comes about, then the DPO has to be located in India. Now, when data transfer to the US happens, that cross transfer of data being Indian employee data, there is no prohibition under the Act, provided you follow the requirements of the Act, including consent. And the central government has not prohibited transfer to the US.
Next question is from Manoj. Which attributes of the individuals are considered as highly restrictive data? Does information like name, office, phone, email, and are personal data? And is there segmentation like highly sensitive personal data and others?
Yeah. So who did you say the question was from?
Manoj.
So Manoj, I think, has read the Sri Krishna Committee bill because that had a segregation between personal data and highly sensitive personal information. This particular DPDP does not. It only has personal data, and personal data is any data which can be used to identify an individual or which relates to an individual. So as long as you fit within that bucket, it's personal data. Nothing has been classified as highly sensitive or highly personal data in that sense.
Next question is from Rajiv. The applicability of this act in AI platforms like ChatGPT, etc.
Yeah, Deva, you want to take that?
No, sir, I think you can take it up.
Sure. So, I mean, since processing is defined to mean processing either in physical form or through technology, any AI platform that processes data is also covered under this. So the company that owns the AI is ultimately going to be the data processor or fiduciary, depending on whether it is collected or processed the data.
Yeah, just to add on to that, let's say if the individual himself goes on to ChatGPT and uploads those information, then it becomes a.
So I think due to paucity of time, we will have to have a hard stop here. What I'll do is I'll quickly put my email ID in the chat. So anybody who has pending queries can mail them to me, and then I can then forward them to you and get them then the answers.
Sure.
I've just posted my email ID. Everyone, if you could just direct those queries to me. Thank you everyone for joining us today. We hope that you found the discussion valuable and gained a deeper understanding of the data protection laws and their implications for your organization. As we strive for continuous improvement, we value your feedback. Please take a moment to share your thoughts and suggestions with us at the email ID that I've put in the chat. This is devanshu@nasscom.in. Your inputs will surely help us enhance our future webinars. Once again, thank you for your participation, and we look forward to connecting with you again on our upcoming events. Thanks, Aditya. Thanks, Devaya, for taking out time today and enlightening us with your insights.
Yeah. Thanks,
Thank you,
Devanshu.
Devanshu. Thanks to
Thanks.
nasscom. Thank you all for participating.
Thanks, everyone. Have a nice weekend. Bye.
Thank you.